Mindy is the victim in the last case. We're good.
All right, we're ready to go up to the jail?
We are.
All right, the first matter is Buchanan. On deck is Rains.
I'm sorry, Judge, that's the only one we don't have. We can start with Mr. Rains if you're ready.
Okay, Rains and then Bird.
And Judge Bird waived.
All right, thank you. So on Rains, what does the state feel is appropriate?
Yes, Your Honor. In this case, we are asking for an additional $10,000 bondable bail with DAS supervision. Defendant scored a 9 on the underlying case. I think concerningly, that was also a similar incident of regarding an arrest for battery and assault on a protected person that's pending. Defendant also has a gross misdemeanor conviction back in 2022 for taking vehicle without consent. At that one, he failed to appear, and looks like he was sent to mental health court. Ultimately removed. He had his probation reinstated and then ended up closing the case after a jail sentence. Also had a DUI in 2022 in this court conviction. Had a 2021 also gross misdemeanor taking a vehicle without consent where he had his probation revoked. And so given the similar underlying charges, the prior unsuccessful issues with his supervision, we believe he's a risk to the community, risk to continue the conduct, and ask that you set bail. Thank you.
All right, defense.
Judge, we're going to ask bail remain set as it is in the earlier case. I understand the state's concern about Mr. Rains. However, he can't afford that bail either as it currently stands. Given that he can't afford it, it's going to be a de facto hold on him. So we're asking not to raise bail at all.
All right, thank you. The state shown by clear and convincing evidence that bail is necessary to ensure the safety of the community and appearance of the defendant have not been provided any other least restrictive means to mitigate that risk. Therefore, the bail will be set as requested. $10,000 of bail allows make all court appearances. We'll see him back on December 5th for the filing of the criminal complaint in this matter. Bird and then Campbell. I understand Bird waived. What does the state feel is appropriate on this matter?
All right, I'm just pulling my case. I was finishing up my notes on the last one. Yes, with Mr. Bird, we are asking for $5,000 bail. The defendant had a warrant already for failure to appear at a Reno Municipal Court. Defendant has lengthy criminal history. Frankly, is habitual eligible. Looks like one of the past cases that was on the table, although ultimately that was not where it ended up. Criminal history goes back 2006 with a felony conviction in burglary in Modesto, California. Had a 2007 felony conviction for child cruelty in Modesto. I know he had 5 parole violations on that case. Also in that year had a domestic battery and a DUI in Modesto. 2008 had a felony conviction for petty theft with priors, and also 2008 and 2009 had multiple parole violations on each one of those. Has a number of 14, 15 had some traffic issues, both California and here, where he had numerous failures to appear and failures to comply. His most recent felony conviction is a burglary of a motor vehicle here in the second in 23. Prior to that, had a burglary conviction here in the second in 20, also a DUI, obstructing and taking a vehicle without consent conviction in 20. So an individual who has lengthy issues with the criminal justice system, also has had a lot of issues with his supervision and appearing. So even though this is again possession of drug paraphernalia, the issue for the defendant is he just doesn't show up and cooperate. So we believe that bail and DAS and supervision with testing are appropriate. Thank you.
Defense.
Judge, we're going to submit it.
All right. It'll be set at the $5,000 of bail allows make all court appearances December 5th at 9 a.m. to defense next court date. Thank you. Well,
And Judge, you asked for Buchanan, and Mr. Buchanan, I've been informed, has refused.
Okay,
The first name that you called this morning?
all right, yeah, so you want to come back tomorrow?
Sure, thank you.
Okay. So. Right, he did, and he did, I wonder if he has one of those other cases. Sorry. All right, Campbell and then Carl. What did the state feel is appropriate?
Yes, sir. In this case, we're also asking for $5,000 on Mr. Campbell. He's got length of criminal history going back to 2006 in California. Looks like he's been in this area since 2017. What is most concerning for Mr. Campbell is he had two failures to appear in 2023. Looks like there are misdemeanor conviction for possession of drug paraphernalia, and had a parole violation arrest also in that year. Last year, he had a possession of drug paraphernalia and trespass. So a lot of his issues are misdemeanor convictions here in this jurisdiction. However, again, given those fairly recent failures to appear, we believe that some bail is appropriate to ensure his attendance. Thank you.
Judge, he
Right.
doesn't have a history of failing to appear. He was not causing any problems when he was stopped for having a whip around his waist, perhaps using it as a belt. Given that particular set of facts and given a history of a lack of failures to appear, I think there are least restrictive means to keep Mr. Campbell under court supervision, including putting conditions in place, making sure he has regular check-ins and drug testing. We're seeking an OR in this matter.
All right, I appreciate that. Unfortunately, high-risk drug offenses fail to appear and fail to comply more than any others, and he's got case with us every year, 2022, 2023, 2024, 2025, consistent with that score. So bail we set at $5,000, bondable. Obey all laws, make all court appearance, next court date, December 5th, and 9:30 a.m. All right, Caro and then Estrada. What state feels appropriate?
Your Honor, we are still trying to reach out to the victim for her input on this case. We've left messages but haven't heard back. We would ask for another day, and but we would ask for a no contact with the victim, Miss Elizabeth Gutierrez, in the meantime, so they can't call her from the jail.
All right, no contact, and we'll see you tomorrow, sir. Thank you.
More. Yeah.
Estrada and then Gurloa Banuelos. On Estrada. On Estrada, we need the winds check. The administrative order from the Nevada Supreme Court says an NPRA must be done on everybody, so we'll have to see you tomorrow, sir, to get that NPRA. Gurloa Banuelos and then de Klerk. All right, what does state feels appropriate on this matter?
Yes, Your Honor. In this case, we are asking for $15,000 bondable bail. No contact with the victim. Sorry, I know I have his name in here. Fred Irizarry. And supervision and bail laws. To be candid with the court, Your Honor, I spoke with my staff this morning. He was arrested for the eluding in Sparks from the couple days prior. I don't believe he's been seen in Sparks yet, possibly tomorrow. I do anticipate filing these cases jointly in Sparks. But in the meantime, we are asking for bail and supervision until we can get all that paperwork straightened out.
All right, Spence?
Judge, I'm not aware of any case in Sparks as it currently stands. In this case, we were able to contact his person and find out that he has a place to stay and he has a job at that place. That takes his score from an 8 to a 6. And so I think appropriate conditions could be set. I understand I may not be able to get an OR today, but if he's released on this case and held on the Sparks case, then that might be the appropriate amount of bail in this matter. This is currently charged as a possession of stolen motor vehicle and the identification of another individual. Last but not least, he's been here for 5 years, Your Honor. I'm not sure he's a threat to run. And he does not, from my review of his criminal history, have a history of violence.
All right, so he had a arrest with us in July for credit card fraud and identity theft. That was eventually no issued. Then he was arrested in Sparks for felony eluding yesterday. And then he has these charges. That coupled with the 8 on the risk assessment indicate that he is a danger to the community. Therefore, bail is necessary, and it'll be set as requested by the state, $15,000 or 10% cash. Bail laws, make all court appearances, no contact. We'll see him back December 5th at 9:30 a.m. for the filing of the criminal complaint. Thank you, sir. The clerk, and we have a victim on this last matter. All right, will the state feels appropriate?
What's your name?
Dana Marie.
Just asking to make sure I know.
Oh, okay.
Yes, Your Honor. So I would note again, as the court noted, the victim is on the call. I don't believe she necessarily wishes to speak. She indicated that when asked about the no contact order, that she didn't think the defendant was ever going to try to talk to her again. It does seem like drinking is at issue between them. That that the victim at the time didn't know that she was drinking. So in this case, we are asking for $7,500 bail. We would ask for the no contact order with Miss Roy Lance. We would also ask for DAS supervision and testing for alcohol, as well as no weapons, given that this is a crime of violence. So I don't show any convictions for her. However, she does have 3 prior domestic battery arrests. Looks like the first one was in 2003 in Martinez, California. Then in 2008, that one looks like she was given a drug court deferral on a felony arrest for domestic violence, and then had a 2016 domestic battery arrest that looks like it was declined out of Oakland. So no convictions, but it appears that violence has been an issue leading to arrest in the past, and it looks like she's had issues with substances for quite some time. So with that, I'd submit it, Your Honor.
Right, Spence?
Judge, I saw that she scores a 5 on the MPRA. We were able to confirm her phone number. So that lowers her to a 4 and a different residence that she could stay at. So that makes her a 2, Judge. Given that those things happened in the past and she's struggling with mental health issues now, she also has psychiatry appointments that she attends on a regular basis once a week. I'm asking for an OR release here. Also, vocational rehab approved her for a full scholarship in culinary school, which she's supposed to be starting in the spring. So she has things that are going to tie her to this community, and she has an opportunity to get her stuff together. Given that the MPRA is the one tool that we use to really evaluate whether or not we should keep people in and whether or not they're a threat, even the victim says she's not a threat to do more harm. I'm asking for an OR in this matter.
All right, thank you. Miss, is it Roy Lance? If you unmute yourself.
Yes, sir.
All right, what would you like to say?
It was Thanksgiving. It's
the first year of her anniversary of her mom's passing away. We knew it was going to be a difficult one, so we took the risk in hanging out and doing dinner. So my apologies to the court. We did know that this was a hard time for her, so I don't want to file any complaints or anything against her. And she's also going for disability for mental health, and she is getting her stuff together. It just was she fell off the wagon and just got to get back up on there. I'm willing to cooperate in any way I can help.
So you think she should be released?
Yes, and I know she won't come here to do any harm. Her vehicle's secured, so is her items. I will leave the premises with the keys to her vehicle on my doorknob so she can get it, which is, I have 2 cameras that would confirm nobody would steal her vehicle or anything like that. So she's fully protected, and I'll give her space and time and the room to grow, because I know she's capable of becoming a better person.
And what conditions should I set? Do you want to have contact with her?
Not at this time, no.
Okay. And then do you think alcohol use or drug use contributed to this event?
It was alcohol. It was peppermint schnapps. So, it was just a stupid slip is all for her. So, she was 6 months sober. She was doing great. She is in therapy and counseling and voc rehab. And like I said, it's just the holidays. You know how depressing that can get. But she doesn't use drugs either. So.
All right. Well, based on what you've said, based upon the public defender's effort to lower this or get the score accurately reflected as a lower risk to reoffend or fail to appear, I think I am constitutionally compelled to release her on her own recognizance. There'll be no contact, simple criminal offense pursuant to NRS 178.445 for the maximum 120 days. There'll be alcohol testing, no drug testing. No firearms. Checking with DA's is order to obey laws, make all court appearances. December 8th at 9 a.m. is the defendant's next court date. I think that's everyone up at the jail. Is that right?
Yes, it is, Your Honor.
All right. Have a great day. Thank you.
Thank you, you too.
Anderson paper. Okay.
Hasta la vista.